You're listening to Dakota Spotlight. My name is James Wallner. This is a type of breaking news, you might say, related to the podcast and specifically Season 3, The House on Suite and 7th. There has been an important update on Brian Erickstad's sentencing. I'm going to try to explain it to you quickly, the way I understand it anyway, while I'm drinking my morning coffee. If you've been following Dakota Spotlight over the years and you know the name Brian Erickstad, he was convicted in 1998 of 2 counts of murder in one of North Dakota's most chilling criminal cases. Today, more than 25 years later, the North Dakota Supreme Court has ruled in his favor. But before we go too far, let me be clear, this decision does not overturn his conviction. He's not being released from prison. What this ruling does concern is something more technical, and it has to do with when Erickstad might be eligible for parole. So let me take a sip of my coffee here and then try to break this down. Back in 1998, when Erickstad was sentenced, the judge imposed life in prison with the possibility of parole on the murder charges. That means that, at least in theory, he could someday be released, depending on a whole range of factors. The judge at that time even mentioned that parole might be possible when Erickstad was in his 50s. This was just something the judge said. It wasn't part of his sentencing. Let's fast forward to 2017, and Erickstad receives a letter from the district court informing him that a 1997 law, so one that had been on the books even before his conviction, might affect how his parole eligibility is calculated. This law says that for people sentenced to life with parole, the sentence should be based on that person's life expectancy, and that parole becomes possible after serving 85% of that expected lifespan. It's a technical change, but it has real consequences, and here's where it gets more complicated. In 2022, the North Dakota Department of Corrections and Rehab filed a memo with the district court. In that memo, they asked the court to officially amend Erickstad's sentence to include his life expectancy, which under the rule determines when he becomes eligible for parole. So what happened next? The court agreed. A judge signed off on an amended judgment calculating Erickstad's life expectancy, in effect pushing his parole eligibility out to when he's nearly 79 years old. But here's the kicker. Erickstad was never told this was happening. He wasn't given notice, he didn't get a memo, he wasn't given a chance to speak or respond in any way. The change to his sentence was made without him ever knowing, at least not until it was already done. So in May of 2024, Erickstad challenged. He filed a legal motion asking the court to correct what he claimed was an illegal sentence. He argued that his rights had been violated in several ways. Number 1, he was not notified of the change or given a chance to respond. Number 2, the rule used to calculate life expectancy wasn't properly in effect at the time of his original sentencing. And 3, that the amended sentence might violate the Constitution's ban on ex post facto laws, that is, laws that retroactively change the legal consequences of actions that were committed in the past. And here is the Supreme Court's ruling. Just this week, the North Dakota Supreme Court weighed in, and they agreed, at least on the first point, the lack of notice. The justices ruled that Erickstad should have been notified before the amended sentence was issued. Under rules of criminal procedure, a court can make corrections or amendments to a sentence, but it must give appropriate notice to both the defendant and the state. And in this case, the court did not. Now, there's some indication that the Department of Justice may have notified Erickstad's attorney at the time, but they couldn't prove it. The Supreme Court called this an abuse of discretion, and that alone was enough to reverse the lower court's decision. So what does this all mean? What happens next? First of all, this does not mean that Erickstad's sentence is thrown out. What it means is that the amended judgment from 2022, the one that calculated his parole based on life expectancy, is no longer valid. The case is now sent back to the district court. This time, the court will need to do it properly, meaning with notice, with hearings if necessary, and with the opportunity for Erickstad to be heard. Also important, the Supreme Court did not weigh in on Erickstad's other arguments, like the constitutionality of applying the life expectancy rule retroactively. That's a lot of syllables in one sentence. They specifically said that because the notice issue was enough to decide the case, they didn't need to go further, at least for now. So, while this isn't a reversal of guilt, and it doesn't mean parole is happening anytime soon, it is a rare win for Brian Erickstad and a reminder that due process matters even decades after a conviction. I'll keep an eye on this case because what happens next could set the tone for how North Dakota handles similar cases where life expectancy calculations come into play. Thank you for listening to this update on Dakota Spotlight. I'm James Wallner, and I will see you next time.